Does an FIR prove you're guilty, or is it literally just the starting line? You know, a lot of folks think the second a first information report is filed, the game is totally over. But legally, no way. That couldn't be further from the truth. Honestly, assuming an FIR equals instant guilt is probably one of the absolute biggest misconceptions in the entire legal world.
So welcome to this explainer. Today, we are decoding what is arguably the most crucial document in criminal procedure, the first information report. Whether you're a legal pro grinding for your competitive exams, or you just want to know how the justice system actually works behind the scenes, we're going to break down its registration, its contents, and its true legal effect. Let's get into it.
Okay, Section 1. What is the FIR? The touchstone of criminal law.
So, under Section 154 of the Criminal Procedure Code, the FIR is the formal document recorded by police the moment they receive information about a cognizable, or, a serious offense. It's the spark that kicks off the entire criminal process. And it is incredibly powerful because it basically freezes the original time, place, and version of events right then and there, way before anyone has the chance to change their story. Now, to really grasp its weight, look at the Supreme Court's stance in the Haji Muhammad Akram case. They called the FIR a touchstone against which prosecution evidence is tested. Meaning, if a witness gets on the stand later and contradicts this very first report, boom, it creates serious doubt and can absolutely destroy the prosecution's entire case. Moving right along to Section 2, the mandatory duty to register under Section 154 CRPC. The absolutely critical word you need to remember here is shall. Registration is mandatory, guys, not discretionary. If you report a cognizable offense, the police cannot legally just brush it off and substitute the FIR with some informal entry in the daily diary or Roznamcha. They shall register it, period, end of story.
Now, what's really interesting about this is how the Supreme Court laid it out in Mestit, Razia BB versus SHO. They made it crystal clear. The police have no authority to conduct a preliminary inquiry before registering an FIR. Basically, the cops can't legally stall you by claiming, hey, we need to investigate this first. No. Registration comes first, investigation follows.
All right, Section 3, Essential Contents and Signatures, Building the Foundation. A legally valid FIR requires some very specific building blocks. We're talking the complainant's name and address, the exact date and time it was reported, and the specifics of the offense itself. Plus, it has to list any known offenders or state if they're unknown, any known witnesses, property involved, and finally, this is key, the signature or thumb impression of the person actually reporting it. And getting that signature, it is definitely not just a rubber stamp formality. The police have to read the FIR back in a language the informant actually understands. They have to explain the contents, allow for any corrections, and only then do they get the signature. Just imagine, say Amina reports a case of domestic violence, but the officer just skips reading it back to her. Fast forward to the trial, and the defense argues the written FIR totally exaggerated her actual words. Skipping these steps, it literally hands the defense massive leverage on a silver platter. Which brings us to Section 4, Fighting Refusals and Delays. What to do when the system stalls. Let's map out exactly how this builds. If the police unlawfully flat out refuse to register your case, here is your precise legal roadmap. Step 1. Request the station house officer under Section 154.1. Step 2. Send your complaint in writing straight to the superintendent of police under 154.3. Still hearing crickets? Step 3. You escalate it to the courts. Apply to a magistrate under Section 156.3 to legally force them to order an investigation. Now, let's talk about time, because delay is hands down one of the most intensely litigated issues in criminal courts. An explained delay, like, say, the victim was hospitalized or being heavily intimidated, that doesn't fatally tank a case as long as it's credible. But an unexplained delay, that creates a massive cloud of suspicion. It heavily suggests that the extra time was used to sit around, deliberate, and fabricate a story.
To put that into perspective, imagine an alleged murder happens at 10 p.m., but for 40 straight hours, total silence. Nobody says a word. Finally, at 2 p.m., 2 days later, the FIR is lodged. Let me tell you, for a defense attorney, an unexplained 40-hour gap like that is pure gold. It gives them immense ammunition to stand up in court and claim the family used all that time to cook up a story and falsely implicate their rivals. And the Supreme Court absolutely reinforces this reality in the Qudir Ahmad case. They stated unexplained delay, court is entitled to infer that the delay was used to deliberate on the case and embellish or fabricate the account. A stalled clock can literally be a fatal blow to a prosecutor's case.
Okay, moving to Section 5, non-cognizable offenses under Section 155 CRPC. Let's do a quick rapid-fire comparison. For a serious, cognizable offense, an FIR is mandatory, right? And police can investigate and arrest immediately without needing a warrant. But for non-cognizable, lesser offenses, it is a totally different ballgame. The report is just a prescribed book entry. Crucially, the police cannot investigate or arrest anyone without a magistrate's order. This acts as a massive safeguard, protecting citizens from arbitrary police harassment for minor issues.
Finally, Section 6, evidentiary value and quashing, testing the truth.
So the crucial point here is how this document is actually used in a trial. Legally, an FIR is used to corroborate the complainant's trial statement, basically proving their story has been consistent from day one. On the flip side, the defense can use it to completely contradict that same statement. It can even act as a dying declaration if the informant passes away. But remember, an FIR is just a tool to test consistency. It is definitely not an automatic guilty verdict. This was perfectly highlighted in the landmark Ghulam Hussain case. The FIR is not substantive evidence. Its contents do not prove guilt. It's literally just the very first account given to the police. So no matter how damaging the written words might look, the presumption of innocence always survives the FIR.
But hold on. What if the FIR is just a total malicious setup from the start? Enter the concept of quashing under Section 561A CRPC. This is the High Court's inherent, built-in power to completely cancel an FIR to prevent the abuse of the court process. It's kind of a nuclear option that bypasses the trial entirely, though, as you can imagine, courts use it very, very sparingly.
And this brilliantly illustrates how the High Court acts as a shield against malicious prosecutions. But to use this shield, the grounds have to be severe. We're talking situations where the report doesn't actually disclose a real offense, or it's a clear manifestation of malified intent or harassment. Maybe the allegations are just inherently absurd, or there's an express legal bar, like the whole thing is just time-barred. Which leaves us with one final, pretty heavy thought. If the FIR is the absolute foundation of the prosecution's case, what actually happens to our justice system when that foundation is built on an unexplained delay or a completely manufactured lie? It really reminds us of the incredibly fragile balance between swift police reporting and the actual genuine pursuit of truth. Thank you so much for joining me on this explainer today, and as always, keep questioning the evidence.